15 minutes to present your argument. Please remember our rule that we don't refer to victims or children by name, if that applies here. We've read the briefs and we're prepared to proceed if you are, Attorney English.
Yes, I am. Thank you very much.
Sure.
May it please the court, my name is Brent English. I am counsel for John D. Howard, who is the appellant in this case. The issue in this case is pretty straightforward. The question is whether or not the trial court erred in finding that there was reasonable, articulable suspicion to arrest my client or to stop my client and ultimately to arrest him for driving while under the influence of alcohol on February 2nd of 2020, excuse me. The facts are really important, so I want to lay them out very carefully. At about 2:30 in the morning, a police officer named Josiah Custer was in the Worcester area, and he observed what he thought was my client leaving a bar in downtown Worcester. He saw my client walk toward a vehicle, but never saw the client get in the vehicle and never saw him driving the vehicle. The officer proceeded eastbound on State Route 30, and then ultimately decided that he was going to turn around and come westbound because he saw a vehicle well ahead of him that he assumed but did not know was John D. Howard. He went 100 miles an hour to catch up with Mr. Howard on State Route 30. He did not observe any traffic violation or bad driving of any kind while Mr. Howard was proceeding down the road. They proceeded for about 4 miles until they got to Fry Road. Fry Road it enters State Route 30 from one direction. Mr. Howard put his left turn signal on as he was required to. He stopped. He waited for traffic to come beyond him going westbound, and then he turned onto Fry Road, and he was thereupon stopped by the state trooper, Mr. Custer, allegedly for violating a non-existent rule, which is that he could not turn without going further to the right than the officer thought he should have. Now, the evidence shows that there is no marking on the road that establishes where on the road he should go. Now, the most important fact in the case is that there is a dash cam video of this entire incident. And the dash cam video does not show, and in fact, it affirmatively shows that Mr. Howard had done nothing, and I mean nothing, illegal as he went down State Route 30, as he turned left onto Fry Road, and before he was stopped. Now, it's clear under the law that there needed to be reasonable, articulable suspicion to believe that he had violated the law. And if he had committed a traffic offense, that certainly is sufficient under the precedents of this and other courts. However, there is no evidence in this case that he did any such thing. And the trial court simply erred in concluding that, well, he must have done that because the officer claimed he did that, even though on the video, which is an unequivocal, objective piece of evidence that shows you what really happened here, there is no evidence whatsoever that he violated the law in any manner.
Now, didn't the court review the video and indicate that the back of the truck bounced because it left the roadway or went outside of its lane of travel, something to that effect, that they saw that the back of the truck indicated that he left the roadway?
Yes, he said that. With all due respect to the court, that's erroneous. And the reason that the video is in the record is so that this court can see whether or not there is any support for that contention. And
Okay, thank you.
I urge you to look at that video. It takes 5 minutes to take a look at it, and you will see that there is no basis whatsoever in our judgment for that conclusion.
I'm sure we will take a look at the video. Thank you.
Okay. Essentially, that is my argument in this case. I'll be happy to answer any questions the court may have.
Sure. Judge Hensel, any questions?
No.
And Judge Callahan, any questions? All right, well then, thank you, Attorney English, for appearing today by video. We'll take the matter under advisement. We'll certainly look at that video and render our decision in due course. The clerk of courts, as you know, will mail a copy of the decision to you on the day it's released. And also, as you know, the Supreme Court of Ohio posts our opinions on their website as well. With that, the court will be adjourned.